Hello, hello, hello. Good morning, government students. This is a recorded lecture for learning module two, learning module three. We're still in lesson two, but this is the second half of it. So it's part two of lesson two. And we're still looking at the founding of American national government. These are the objectives I hope that we can accomplish um, through the rest of this lecture or lesson, learning module, however you want to look at it. I want to remind you a little bit about some things that I lectured on with the last learning module, and that was the Articles of Confederation. Remember that it was our first constitution, our first governing document in the United States. It's called the Articles of Confederation, and it served us for about 8 or 9 years, depending on what dates you go by. It was officially went into force on March 1st, 1781, even though it was adopted a few years before that. It took quite a while for it to be ratified. So that's the reason for the difference in time period. But it's officially in force from 1781 through 1789. And if you recall, it was not working that well for us. Our government, which was just one body of people called a Confederation Congress with lawmaking power, um, it was totally underfunded. It had no reliable source of tax income, and was heavily dependent on cooperation by the states to get any funding. So it wasn't able to do very much, couldn't provide very many government services, wasn't even able to pay soldiers fighting the Revolutionary War or give them the supplies that they needed to fight, for the most part. And so it hampered us throughout the war, even though we managed and were successful in the end. But then in peacetime, it became even more apparent that the Confederation government did not have enough power. There was no enforcement arm, there was no judicial branch, there was not enough money. And so when a crisis occurred, which we talked about a bit last time, Shays' Rebellion, um, it just was sort of the straw that broke the camel's back. They could see plainly that there wasn't enough power in the national government to even protect and serve the citizenry. I want you to notice the dates now. This is a bit of a timeline here. So I mentioned when the Articles of Confederation were in force, and you see the dates of Shays' Rebellion, 1786 to 1787. That was towards the end of the time period. It was after right at the conclusion of the war. Um, and as I said, it taught us all a lesson that the Confederation government simply did not have enough power and needed to be changed. So some of our founding fathers called for another constitutional convention to be held in Annapolis. And if you look at the dates, this was right after Shays' Rebellion began, pretty quickly after it began. There was a call for a new convention. This is the place. I just happen to have a picture of where the convention was held, Man's Tavern in Annapolis, Maryland. Unfortunately, not enough delegates came. So you could tell there wasn't quite enough political will to reform the Articles of Confederation at this particular time. And what it took was for the right people to give their attention to the problem. When I say the right people, I'm referring to one person in particular, George Washington. Remember, he was the general of the Patriot Army in the Revolutionary War. To the extent we had an army, it's really just a collection of militia from the various states. But he was leading them or trying to lead them and was successful and had he was held in high esteem. He had a wonderful reputation, and people looked to him for leadership. They were used to looking to him for leadership. And so when he decided, yes, we must do something about the Confederation government, that's when others got on board. This is a quote from a letter that he wrote to, it was a letter from George Washington to James Madison. You notice the date, November 5th, 1786. So still during Shays' Rebellion, but after the Annapolis Convention. And clearly he's learned of Shays' Rebellion by this time in November, and his response is the consequences of a lax or inefficient government are too obvious to be dwelt on. 13 sovereignties, he's referring there to the 13 separate states, pulling against each other and all tugging the federal head will soon bring ruin on the whole. So you can see the evidence there of a crisis in the country. And when George Washington recognized that crisis and called for a solution to it, that's when you got enough. You got the rest of the people who needed to be present for the convention. The founding fathers decided finally they would come and tackle this problem. So we have another constitutional convention here, a few months after George Washington's letter. So May 25th to September 17th, 1787. This is summertime in Philadelphia. Here's a picture of the convention hall there in Philadelphia, where is about 55 men met. It's actually a rather small room. And I think you can kind of tell that by looking at this picture. And then that's the famous painting of the convention there. But I'm showing you these pictures to emphasize summertime in Philadelphia is actually quite hot. The windows are closed. They were closed then. And that was because the men who came wanted absolute secrecy. They needed to be able to speak freely with one another, offer their opinions without fear of being overheard by people in the streets of Philadelphia who might go about spreading gossip or inciting others to protest or disrupt the process. So they needed to have the freedom to say what they needed to say without fear of any retribution. And that's why they kept those windows closed. But it would have been extremely uncomfortable because there's little air circulation. They are not dressed for summertime, as you can tell in the painting, and the windows are closed. So it's hot, stuffy. People probably don't smell very good. It's an unpleasant situation. So have that in the back of your mind as we go through what actually happened there. So the delegates come to Philadelphia now for a convention, and they have authority from their various states to revise the Articles of Confederation. But again, one of its weaknesses was that it required a unanimous vote in order to change it, which meant all 13 states had to agree on any detail, even the most minor details. So it was nearly impossible to change it. And that was the reason why they just had to start over. There was no other option really but to start over with a new document. And it was going to be controversial, and it almost didn't succeed. And there were three, what I call the main points of controversy or the main points of debate. I isolate it to three. Other people may say more than this, but I will ask you to focus on these three. First of all, is what you might think of the obvious controversies: power. We had a central government, but the states, the 13 individual states, had most government powers. And that's the way that people in the 13 states wanted it, because they weren't comfortable with having a very powerful central national government. Their last experience with that was Great Britain as a national government, and Great Britain had abused its power, and they had just fought a war to become independent and against that national power, and they're not interested in replacing it with another very powerful national government. And that's why the Confederation government was so weak. They wanted it that way. But by this time, due to all the weaknesses in the government and Shays' rebellion, everyone recognizes some additional power should be given to a central government. But how much additional power was the controversy? Just how much are we going to give it? And so state governments recognized they were going to have to give up some additional powers, but they were very reluctant to give up very much. And there was also some controversy over the way powers would be divided up among the branches. All the delegates agreed that we should change from having just a Congress, one branch of government, to three, a legislative, executive, and judicial branch. So separation of powers was accepted, but just what powers would be assigned to those three branches was controversial. There was also a good bit of debate over how representatives would be chosen for the serving in the national government. How would we elect the president? How would we elect members of Congress? That debate was one of the biggest debates, along with power. The third that I ask you to focus on is slavery. And this is a huge issue that actually was not fully resolved during the convention. Some compromises were made to accommodate slave owning states so that they would ratify the Constitution. Ratify means give formal approval. So some accommodations were made for slavery for the sake of getting the Constitution ratified, but abolitionists were not successful at this time, and slavery was a point of controversy. We're going to focus for just a moment on one of those controversies, and that is representation in Congress. You may have studied this in high school or previously in college, but we need to focus on it in this course as well. As soon as the delegates recognized they were going to have to start anew with a new constitution, we needed a plan for what that new constitution would look like. And one of the delegates from Virginia named James Madison had a plan. I mean, he came to the convention with a plan, and it was known as the Virginia Plan. James Madison was from Virginia, and he was using some of the ideas from his own state government to come up with a plan for a national government. Virginia happens to be a densely populated state. It was one of the first colonies there in Jamestown. And so over the course of 150 years, there was a large population living in the state of Virginia, as well as in New York and a few other states. And because of their high population, they believed that the number of representatives that a state should have in the national government, in Congress in particular, should be determined by the state's population. The more people you have, the more power you should have in your national government. That was their point of view. So they proposed that representation be based on population. They also proposed that we divide the legislative branch into two chambers, into a Senate and a House of Representatives. And they would have referred to the Senate as the upper house, and then the House of Representatives as the lower house. So that was their idea that James Madison brought, and it was favored by other states that had high population. Higher population yields more representation, which means more power in the national government. Well, as you might expect, states that weren't so highly populated did not like that plan. They essentially wanted to keep things pretty much the way they were in the Articles of Confederation, at least as long as the legislative branch went. They wanted to separate into three branches, but the choice of representatives in the legislative branch, that's what they wanted to keep, where each state was equally represented. Under the Articles of Confederation, the previous Constitution, each state had one vote, regardless of how many people were in it. And that made sense for a confederation because a confederation is just a sort of a unity of 13 separate states. So they don't see themselves as a nation of people. They saw themselves as a union of separate states, separate sovereign states. And when you look at it that way, as these separate entities, you only need one vote for each state. Equal representation would be considered fair under a confederation. And they wanted to just keep the legislative branches one house. So that was the contrary proposal. So you have these two competing proposals there before the Continental Congress, and they absolutely cannot agree with one another. And it becomes very disagreeable, discordant, I guess is the best word. They're very argumentative and insistent on their own way. And it seemed as if the plan was going to fail and our nation was just going to come apart and we would just be 13 separate nations and not one nation. And the men there knew that other countries are looking at us. I mean, we are this grand experiment in democracy, and they're looking to see, is it going to succeed or are we right and it's going to fail? And so the pressure is on them as well to come up with a solution. And fortunately, we did. Another delegate, whose name I always forget, presented a compromise after a couple of weeks of fighting. And this is what was ultimately adopted. It's known as the Great Compromise. And it is great because it quite literally saved our country. Because it's a compromise, it's going to borrow features of both of these plans. Nobody gets everything they want, but everybody gets something that they want. So one of the things that came out of the Virginia plan was a bicameral legislature. That means two chambers. So we got a Senate and a House. That's what we have today. In the Senate, and here's where the New Jersey plan got a little what it wanted. In the Senate, each state would now have two votes, but still each state is equally represented in the Senate, regardless of how many people were in each state. And something I don't have up here on the slide just yet, we'll study it a little more. At this time, state legislatures, not the people of the state, but state legislatures elected their representatives in the Senate. So the Senate would have been sort of a platform for state legislatures. So it's very much the chamber for state sovereignty here. In the other house, the House of Representatives, this chamber, here's where the Virginia plan was borrowed from. In the House, the number of representatives from each state is determined by the state's population. So here you see a reflection of popular sovereignty, that we are a nation of people, individuals having a vote, and they directly elect their representatives in the House. All right, so that was the compromise. That is how we got past that troubling controversy of a representation. But as you know, that there were other controversies, and the next one I'll focus on is slavery. This is a map of the United States around the time of the convention. And you can see here in the map that there are pink states, and then there's blue states, and then there's this well, they're settled, but they aren't states yet. This is a territory still, the Northwest Territory. And slavery is prohibited, if you recall, by the Northwest Ordinance. So these would become non-slave states or free states, but they had not officially formed states yet, so they had no delegates at the convention. But the blue states here were free states. They did have delegates. And then the red or pink states here are slave-owning states. And there are more slave-owning states than free states. It was an 8-to-5 ratio at this time. So that's sort of the makeup of the convention delegates, or at least where they're from. And slave-owning states have a great deal of power. And so, whereas perhaps delegates from the free states would have abolished slavery, they couldn't. There had to be a compromise on slavery. And one of those compromises is known as the Three-Fifths Compromise. And it pertains to representation as well. I know we just talked about how representatives would be chosen. And if you recall, in the House of Representatives, the second chamber of Congress, representation is based on population. So the higher your population, the more representatives you have, the more power you have in the House. So, as far as slave owning states are concerned, they think slaves should be counted. Slaves make up, in some instances, in South Carolina, a majority of the population of South Carolina were slaves. So, counting them would have given South Carolina and other slave owning states greater power in the House of Representatives. So, they wanted slaves to be counted for that purpose. But population was also going to be the basis for determining how much taxes would be owed by each state. So in that realm, slave owning states did not want slaves to be counted because they wanted lower population count for purposes of taxation. But they couldn't have it both ways. The delegates would not go for that. So the compromise then is we're going to count 3 out of every 5 slaves. Another way to put it is 3/5. You call it the 3/5 clause because it does, in fact, treat slaves as 3/5 of a person. It was extremely unjust. Either way you look at it, either not counting them at all or only counting them partially, a grave injustice. But it accomplished a compromise that allowed the ratification of the Constitution. I'm not justifying it, I'm just explaining what happened. Some other trade offs were, and I'm sorry, that's for purposes of both representation and taxation. Slaves would be counted 3 out of 5, that ratio there for both purposes. That was the compromise. Some other compromises included the international slave trade. Before the Revolutionary War, if you recall, part of the mercantilist system involved a middle passage. This would have been the importation of humans across the ocean from Africa into the American colonies. And that is international, right? It's coming from Africa and the nations of Africa into America. And that international slave trade was part of the mercantilist system. It was part of what was working in the economy for all of the colonies. During the war, it ended temporarily because of the fighting along the coast. We were not importing slaves at that time. But when the war was over and peacetime resumed, so did the international slave trade. And that is fueling the economy of the slave owning states to be able to bring new slaves in as the labor force for the agricultural economy in the South. And so the slave owning states wanted to continue with that. Those interested in abolition were opposed to it. The compromise was that it would end in 30 years. So we're here working in 1787. The slave trade, according to the Constitution, would end in 1808. So that would be, I may be doing my math wrong, 20 or 30 years, however the math works out. They would have a period of time for it to continue, but it would and did come to an end. Slavery didn't, just the importation of people. The last trade-off we'll mention is the Fugitive Slave Clause. This was a provision of the Constitution that allowed slave owners to seek extradition of their slaves who escaped. So let's say there was a slave in Virginia who was able to escape from slavery and make it into Pennsylvania, which is a free state. Under the Fugitive Slave Clause, the slave owner could come into Philadelphia if the slave was found and claim him or her and force them to come back. And Pennsylvania had to honor that right of the slave owner to come and get the escaped slave and bring them back. And that was another compromise during the convention that affected slavery. slavery really wasn't fully resolved. It continued to be the subject of controversy, as did state sovereignty. That was a matter that continued well into the first few decades of our nation. So we get a constitution adopted in September of 1787. And I want us to look at some of its details and key features. And we'll start with the preamble. So I can make some, just want to make some important points. I know it's just a preamble. It doesn't really have any legal effect, but it does reflect the point of view of the founders of our country at this time. So we start out by the first few words: we, the people of the United States. That's different from the Articles of Confederation in a very important way. If you remember, the Articles of Confederation, this is in a previous slide, the very first article of it said, the style of this confederacy shall be the United States of America. Okay? You don't see the words the people here. That's in the Constitution, but not in the Articles of Confederation. And there's a reason for that. These words here, we the people, reflect a choice that the source of government power are the people. The new national government is deriving its power directly from the citizens of all states. So we are now a nation of people who are consenting to the formation of a national government. The people will have a direct relationship with their national government. States will still have some power as separate entities, but there will be a direct relationship between the people and the national government. That's popular sovereignty. The people are sovereign. They are the source of national government power. And that is made plain by these three words here: we, the people. The rest of the preamble is a statement of the purposes of government and what the founders believed was the purpose of any good government, what it ought to do. So they say, we, the people of the United States, in order to form a more perfect union. So we are uniting in a better way. This is our second go at having a constitution and a national government. We're going to do better this time, a more perfect union, which will establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and to our posterity. And that's what the preamble says. And you see this list. What is the purpose of a good government? Unity, justice, peace, common defense, the general welfare of the people, liberty to ourselves and to our posterity, means your subsequent generations, children, grandchildren, great-grandchildren, on down the line. So a lasting liberty that continues on indefinitely. We talked about a few government principles in our very first learning module. Two of them were liberalism and republicanism. And you can see both of those reflected in these choices, this language here. Liberalism, if you recall, is the belief that good government's primary purpose is to secure the liberty of the people. And there it is: secure the blessings of liberty to ourselves and our posterity. Republicanism means that every good government must set aside the personal interest of elected leaders and support the common good of all, that being the general welfare of the people, the common defense. So we're not just going to serve the interest of any one state or any one group of people or any one person. The laws that our government makes and enforces and interprets would be laws that uphold the common good. That's your reflection of republicanism. And you can see both of those, as well as equality and other things, are reflected here, and just at the very beginning of the Constitution. Okay, I'm going to step away from our PowerPoint slide now because I want to show you the actual Constitution and what it contains in a general way. There are 7 articles in the Constitution, and I'm going to scroll through them. I'm about to click this hyperlink here and take you to a transcript of the Constitution, and I'll scroll through it. And as I go, I'm going to be completing the outline that you'll see on this slide later on. I'm just going to talk through it first, and then I'll go back and show, reveal these chapters. And I'm calling them chapters because I want you to think of each article as like its own little chapter in a book, because each article pertains to sort of a theme. If you can humor me with that when I say the word theme, it's sort of thematic. Okay. Okay, you should now see a transcript of the U.S. Constitution on the screen for this video. I'm at the National Archives website, if you're curious where I'm finding this. And this is a transcript of the United States Constitution, the original 7 articles of it. Here at the beginning is the preamble that we already went through, and you should already kind of get the significance of it. The first article or chapter of the Constitution, Article 1, as you can see here, it tells you exactly what it pertains to. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. So Article 1, its title, chapter title would be establishes the legislative branch of government. You can see the Great Compromise reflected here because we have a 2-chamber or bicameral Congress, a Senate and a House of Representatives. Article 1 is particularly long. It describes how representatives are chosen in the House and then how they'll be chosen for the Senate. Talks about when they'll meet, what they can do while they're meeting, how much that they'll get paid, how a bill will become law, what kinds of laws that Congress can pass. So this is a list of the specific powers, enumerated powers. I'll come back to that word enumerated in a moment. The enumerated powers of Congress are listed here. And then there's 2 sections that limit the power of government. Article 2 says at the very beginning pertains to the executive branch. The executive power shall be vested in a president of the United States of America. He shall hold his office during the term of 4 years, and together with the vice president, chosen for the same term, be elected as follows. And it goes down to explain something we call the Electoral College, which we'll study later. But I just wanted to point out here, Article 2 pertains to the executive branch of government. We have a president and a vice president. And later on, you'll see how the executive branch expanded beyond just 2 people and came to be a president, a vice president, a cabinet, and then a big executive staff. So it's more than just the 2 people. The executive branch consists of many people. And like the Congress, there are enumerated powers of the president that are listed here in Section 2. Article 3 pertains to the judicial branch. It establishes a judicial branch of the United States, which shall be vested in one Supreme Court and in such inferior courts as Congress may, from time to time, ordain and establish. So that would be one court that is actually set up by the Constitution immediately, the one we're familiar with, the U.S. Supreme Court. But then it gives Congress the power to establish inferior courts, and Congress did establish them. We have 13 circuit courts and 94 federal district courts. So the judicial branch is more than just the U.S. Supreme Court. It's many, many courts. And their power is to interpret the Constitution and the laws of the United States. And that power is enumerated, just like the other 2 branch. The powers of the judicial branch are enumerated and limited to just what is set forth here in Section 2. Article 4, a little more difficult to establish a central theme, but for our purposes, we'll say it's state-to-state relationships. Section 1 of Article 4 provides a full faith and credit clause, which means that the laws of any one state must be enforced by other states. Contracts entered into in any one state will be upheld in other states. The second clause here, second section, has the privileges and immunities clause. This means that essentially one state cannot discriminate against the citizens of any other state. And this does apply to you if you you may be a resident of South Carolina, but you might not. If you happen to reside in another state and you're here going to school at Lander, feel confident that the state of South Carolina will give you the same privileges and immunities as South Carolina citizens, because it must, because the Constitution requires that there be no discrimination by one state against the citizens of any other state. Article 5 is all about amending the Constitution. There is a detailed process for how to do that. In the end, it requires the agreement or approval of 3/4 of the several states. And so I don't want any confusion here. I'm going to go over this a little bit more. Under the Articles of Confederation, you had to have a unanimous vote. All 13 states had to agree to amend the to amend the Articles of Confederation. That was impossible to accomplish. So in the U.S. Constitution, our second go around, we made that a little easier, cut it back from unanimous to 3/4 of the several states. But that's to give final approval of an amendment. If you want to introduce an amendment, you only need 2/3. 2/3 of both houses of Congress can introduce, or a second way is for an amendment to come from the states. 2/3 of the several states can propose an amendment to the Constitution. But either way, whether it comes from the people in the several states or from Congress, either way, in the end, to get final approval and make an amendment official, you have to have a 3/4 vote of the states. This is a little bit easier than the Articles of Confederation, but still difficult, still challenging. You still need a super majority of the states to approve any amendments to the Constitution. Article 6 has two clauses that I'd like to highlight for you. One is the Supremacy Clause. If you're looking for a chapter title, you might call this the Supremacy Clause, but Article 6 has a little bit more to it. I'm going to highlight the Supremacy Clause first. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And every judge in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. This is an important clause because it backs up an important principle of our national government. When Congress is acting within the scope of its authority and it passes a law, for example, let's use immigration as our example. It is plainly within the power of Congress to pass laws related to immigration into our nation. That's one of the enumerated powers that you'll see listed in Article 1, Section 8. So Congress has the power to pass laws regarding immigration. However, there are several states who have a big stake in immigration, and those are the border states. And so they certainly have an interest in passing their own laws regarding immigration, and that's okay. But they cannot conflict with the law passed by Congress because of this very clause. Because when Congress acts within its authority, and it is within its authority when it's dealing with immigration, the laws passed by Congress shall be the supreme law of the land. So these would be laws that have a national impact, and immigration does have a national, actually has an international impact. So it is appropriate for Congress to have the final say on our nation's policies with respect to immigration. And that's just an example of the Supremacy Clause at work. But I just want to emphasize, it's not just any law. Congress is limited in its ability to pass laws. And so we'll talk a little bit more about that as we go through the semester. Okay, and the next clause here is known as the no religious test clause. It's this last little section at the end of Article 6. But no religious test shall ever be required as a qualification in any office or public trust under the United States. Um, this reflects a choice that the founders made to not have a national religion in the United States. Many of the state governments, particularly Virginia, South Carolina, definitely Massachusetts and some other states, they had a state-sponsored religion, which meant taxes collected from all citizens went to support an established church within their state. And other nations abroad, also, they had a national religion. Tax dollars from the citizens went to fund a national supported church. In the United States, however, with our new government, our founding fathers decided that we would not have an established church for very good reason, which we will discuss in great depth when we talk about civil liberties. For now, I just want you to recognize here in the original Constitution, before we even had a First Amendment, before the Bill of Rights, there is a choice made by our founding fathers that religion would not control the workings of our national government. We would be a secular government. Okay, next is Article 7. It's the last article, and it has a very obvious theme, and that's ratification. Ratification means formal approval. In order for this new Constitution to have any force and effect, 9 states had to agree to it. Here, it requires 9 states to ratify. So after the delegates to the Constitutional Convention wrote the Constitution, brought it back to the Confederation Congress and presented it, the Confederation Congress approved it, but it had no force and effect until the people of the United States gave their approval. So the delegates there to the Confederation Congress had to go home, back to their particular state, their home state, and present the new proposed Constitution to the people. And that's important. And we will go over that in just a second. Let me get back now to the PowerPoint. Okay. I hope you are now seeing the slide, and I will reveal the titles or the themes for each article again, so you can, if you want to, pause the video and make a note of them. Okay, so next we're going to talk about some key concepts that are throughout, they run throughout the Constitution. And there's 2 in particular. You'll want to commit these to memory. The first is federalism. Federalism refers to the balance of power between state governments and the national government, or you could say national, state, and local governments, because we do have local municipalities, cities, counties, towns, and whatnot. They're part of this federalism as well. For our purposes in this course, we're just really focusing on the national government, but we've got to recognize that our national government was formed in this context of sharing power. So the Constitution lays out the specific powers that would be given to the national government. We use the word enumerated because that just means numbered or listed individually. You could also call them the express powers. Express meaning written down plainly for everyone to see, articulated, set forth. That's what enumerated means. And the Constitution lays them out in quite a great deal of detail, saying exactly what powers our national government will have. And the power of the national government is limited to just what we've written down and given it. So that is the principle of limited government. Our national government's powers are limited to just what we give it in the Constitution. What have we enumerated or given to our national government? That's all the power it has. It can't do anything outside of those powers. So we call that enumerated powers. And we call the principle of federalism or limited government, which is an aspect of federalism. So federalism means that the national government's powers are enumerated here, they are listed. And any powers we have not given to the national government are reserved to the states. So, what we haven't given up, what the people haven't given over to the national government, will go to state and local governments or the people themselves. And that is called reserve powers. That was also an aspect of federalism. You can see in the middle, this is like a Venn diagram. So there are two circles, but they overlap a bit. So there are some powers that both the national government and the state governments have concurrently. They share those powers. And we'll look at those more closely in our next lesson. But as I mentioned when we were looking at the supremacy clause just a moment ago, when the national government is acting within the scope of its enumerated powers, its actions control or are supreme to any of the actions of the state government. And state judges, state governments must respect the actions of the federal government when the federal government is acting within the scope of its constitutional power, its enumerated powers. The second concept is separation of powers, something I'm sure you've heard before. This is the choice to divide up government power into three separate branches: legislative, executive, and judicial. So the legislative branch will have lawmaking powers. The executive branch will have executive or enforcing powers, and the judicial branch will have interpretive powers. And each of these three branches have to work together. They are not completely isolated with one another. Congress writes the law, but the laws don't go into effect until the president signs it. If the president doesn't approve of the law, he can veto it. But if enough members of Congress want the law to be enacted, they can override the president's veto. So that forces a cooperation between Congress and the president. If they want a law to be enacted and they don't want any pushback on it, they're going to write it in such a way that they will have the president's approval. They also must be concerned by the wishes of the judicial branch. If Congress were to write a law, even if the president approved of it, the judicial branch can invalidate it if the judicial branch believes that it violates the Constitution. And so the Congress has to be mindful of what is allowed by the Constitution. Will the Supreme Court invalidate this law? We have to check for that and make sure the laws that we write are constitutional and are supported by the president. So in the end, you have to have all three branches cooperating with one another and agreeing with one another before a law can have true force and effect. And this is an aspect of something called the checks and balances that are inherent in the separation of powers. No one branch has all power, and each branch can hold the others in check, keep them from moving outside of their own little realm, their own little section of power. Okay, remember Article 7 of the U.S. Constitution said that the delegates had to take it back to their states for ratifying conventions. And that's what they did. They left the Constitutional Convention. They brought the Constitution back to Congress and the full Congress and asked that it be distributed to the states for ratification, received Congress's approval and was adopted. But then the delegates took the proposed Constitution back to the states, and each of the 13 states had their own little ratifying convention. They would read the Constitution and decide if they wanted to give their formal approval of it. Some of the states did so fairly quickly, but others were somewhat of a holdout, and I'll get into that now. So the fact that we would hold ratifying conventions, this is a reflection of popular consent. Now we are a nation of people. We have, as individuals, a direct relationship with our national government. So the government needs the people's blessing for the Constitution to take effect. So instead of just having state legislatures get together and look at the Constitution, the people had to look at the Constitution and decide whether they approved of it or not. And they did so in the context of these ratifying conventions. So please keep that in your mind, keep that separate. We're not going back to state legislatures. We're going directly to the individual citizens of each state and having them look at the Constitution and decide whether to give it their approval or not. And they're following this process from Article 7 of the Constitution. This is popular consent. The people are giving their consent to the national government. In these ratifying conventions, there were many debates, similar to the debates that were held in the National Convention. So those same controversies over power, representation, and slavery, they occurred again in these other state ratifying conventions. And an additional issue arose that unlike state constitutions, our national constitution did not have a Bill of Rights. And that was a problem for many of the states. Each state had its own constitution, and many of them had a Bill of Rights that listed certain liberties that would be protected. Our national constitution did not have one, and that became a real big sticking point. As part of these debates, a group of people who were in favor of the ratification of the Constitution decided to write articles. These were essentially like editorial letters that might be published in newspapers. And they were published in the newspapers of the day. And they were called the Federalist Papers. They were named that because this group of people who supported ratification of the Constitution called themselves Federalists. Because they believed in this principle of federalism, that constitutional concept I mentioned before. So they wrote these articles, had them published, and the collection of them all, I think there's 80 something different articles, maybe more than that, I can't remember, but it's a lot of them. And they collectively are known as the Federalist Papers. And so those Federalist Papers are one of the founding documents of our country, and therefore we will read and study them directly. That's one of the assignments in this module. It's for you to read a selection of them. In those Federalist Papers, you had the arguments for ratification laid out. But those who opposed ratification, whom we now call anti-federalists, they weren't organized the way the Federalists were, so they didn't really have an official title. But they were the people who were opposed to ratification. They wrote their own articles and published them in newspapers. So you kind of had this back and forth a bit going on in these essays that were being circulated throughout the states. I have selected a couple of them for you all to read, a couple of the anti-federalist ones for you all to read. And I refer to them as the Brutus essays because the person who wrote them did not give their name. So we cannot know for 100% sure who actually wrote them. The author signed his name Brutus. So that's why we'll call them the Brutus essays. So you have the Federalist Papers and the Anti-Federalist publications, which I call the Brutus essays. We'll look at a selection of both of them to explore the debates that went down in the ratifying conventions. Okay, I wanted to, at the last couple of slides, talk about those debates. I told you that there were sort of two groups of people who formed, Federalists and Anti-Federalists. These are not political parties. These are just groups of people debating whether or not to ratify the Constitution. Federalists consisted mostly of larger scale merchants, wealthy, landowning, educated people who lived along the coast of North America. They are those who have the most at stake in the success of the Constitution. And so they supported its ratification. They were called Federalists. They favored ratification because they believed that the Constitution, as written, didn't require any editing, But as written, it accommodated all the concerns that they had. They believed it sufficiently limited national government powers because it enumerated those powers. It was very plain exactly what the national government branches could or could not do. It was a limited government. Um, it let states have all other powers. So everything not expressly given to the national government is reserved to the states. That was a sufficient protection against tyranny to have enumerated powers for the national government, reserved powers for state governments. They understood the principles of federalism and separation of powers and believed they offered these sufficient internal controls on any particular branch's exertion of power. And they did not think a Bill of Rights was necessary because of these other things, because it was a limited government, because we had separated powers. They believed a Bill of Rights wasn't needed. On the other side of the debate, the anti-federalists typically consisted of smaller merchants and farmers and business owners, people who were seeking to move west and establish farms. They were opposed to the Constitution because, well, for one thing, they had far less at stake in the success of the Constitution. They were more content with the Articles of Confederation, or at least in a less centralized government at the national level. They were opposed to ratification without substantial revisions to it. And some of the reasons they presented in the Brutus essays were that they preferred local or home rule. They preferred to have a closer tie with the representatives in government. And at the state level, they had a very close tie with their representatives. Oftentimes, the elected officials in state governments were your next door neighbor or the guy who owns the pub down the road. You know, these are familiar people. They're neighbors, and they knew they could hold them accountable for laws that they liked or didn't like. And that direct and close connection with the representatives made them feel safe. And they weren't as worried about abuses of power. And so they preferred that it stay that way. They didn't like the idea of having a national government off in Philadelphia with elected officials they didn't really know. They had no way of contacting them. You know, we don't have internet, we don't have telephones. There was less of a connection between the citizenry and elected representatives and a national government. So they didn't want that national government to have so much power. And they feared that those being chosen and sent to the national government would just become another aristocracy, another group of wealthy elitists who are just out to serve their own interest and not seek the common good, the interest of even rural America. They thought America was too big and too diverse to be a big republic. They believed that a confederation was a better form or system of government because of its size and diversity. And they definitely wanted a Bill of Rights because they were so afraid of the power being given to this distant national government. They wanted to have this extra protection in the form of certain liberties written out and plainly made a matter of protection by the national government. So those are the debates. And when you go to do your one of your module assignments is to read a set of Federalist essays and then one Brutus essay. And as you're reading, you're going to be looking for these arguments, looking here. And I've got a set of questions. They're called DBQs, document-based questions, relating to the essays you're reading. And they're intended to highlight these arguments being made in the essays. Our last slide here, our last topic, has to do with changing or interpreting the Constitution. We recall that from the Articles of Confederation, in order to amend it, you needed a unanimous vote. Well, in the Constitution, you only need 3/4. So that's what Article 7 says. You need three-fourths of the states to approve of any amendments to the Constitution. And we have 27 total amendments in the Constitution. The first 10 of them are known well as the Bill of Rights. And we'll study them when we get to our lesson on civil liberties and civil rights. We'll look at the Bill of Rights, the arguments for and against having a Bill of Rights. That will come later. But I just wanted to highlight the fact that we have amended the Constitution. You can change it. It just requires a supermajority, a three-fourths majority in order to change, which is good. You want it to be difficult to change the governing document of your nation. You need to have the support of many, many, many people before that can happen. There is also a way that the Constitution, it hasn't changed in its words. Other than these 27 amendments, the words are the same. But the interpretation given to those words has, in fact, changed over the course of 250 years. And perhaps you are not surprised about that if you take a step back and think about how much our nation has changed since 1789. We're quite a different group of people, far more diverse than we were before, technologically advanced, better educated. Our literacy rates are higher. There are a lot of differences in our country now. Our values have changed somewhat even. So as a result of that, we've seen some changes in the interpretation of the words of the document. The authority to interpret the words of the Constitution was the subject of a very important U.S. Supreme Court case known as Marbury versus Madison. We'll study it in greater depth later, but for now, keep in mind that it took a U.S. Supreme Court decision to really crystallize this power in the judicial branch, the Supreme Court in particular, to have the final say on what the Constitution's words actually mean. Some of it is a bit ambiguous. And an example of that is found in, this is actually in Article 1, Section 8 of the Constitution. It's a list of the powers of Congress. And it says Congress has the power to regulate commerce among the several states. Well, now the shape of commerce has changed quite a bit from 1789 to today. In 1789, we were barely a national economy. The roads, transportation between the states were very limited, dirt roads. A lot of the goods that were exchanged between the states occurred through waterways, so navigation of ships along the rivers that ran across several states. So what it meant to regulate among the several states, that was sort of vague. You could look at it as just the actual transport of goods from one state to another, or it can mean something a little more. And so as our economy changed, as the nature of commerce changed over the years, the meaning of these words to regulate commerce among the several states has changed to accommodate as well. And the Supreme Court has provided a final say on the meaning of those words. And so we'll study that a good bit more, give some more depth and meaning to that later. Just wanted you to understand that the Constitution itself can be changed. Its words can be changed through a relatively difficult amending process. But also the meaning of its words is given certain interpretations that adapt to changes in our economy and our values and our technology as time has gone by. And that is the end of lesson 2. You should now begin work on the learning module assignments. Email me if you have any questions.